I'm Jan Painter, and I'd like to welcome you again back to our program, Politics Matters. Today we're continuing our series on the constitutional amendments. Today we have with us Professor Frederick Schauer, David and Mary Harrison Distinguished Professor of Law at the University of Virginia, where he teaches courses in constitutional law, evidence, and philosophy of law. Professor Schauer holds an AB and MBA from Dartmouth College and a JD from Harvard Law School. He is also Frank Stanton Professor of the First Amendment, Emeritus at the JFK Kennedy School of Government, served as academic dean and acting dean, and also taught courses in evidence and the First Amendment at Harvard Law School. In reading over the amendments, I was very interested in the Ninth Amendment, which is, for many people and most legal minds, as you well know, we were discussing before the program, one of the most interesting of the initial 10 contained in the Bill of Rights. And it states, quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Understanding that, for instance, Robert Bork stated that this amendment is an inkblot, basically one in which you can see in it whatever you wish. Would you wade in a bit for us, Professor, toward an understanding of what this amendment means, presuming that the founders put it in there for a reason?
Okay, it is, as you know, a very controversial issue about just whether what the founders intended ought to guide us today. The words clearly ought to guide us today, but whether the original intent behind those words ought to guide us today is one of the great controversies of constitutional theory. There's no clear answer, and there are continuing debates about whether we ought to be bound by the intentions as opposed to the words that were written in 1787 or 1791. Even assuming controversially that the intentions in 1791 matter, it's important to recognize that those words were written before there was any understanding of the idea of judicial review. That is, the idea that the courts could strike down laws as unconstitutional. The Ninth Amendment was written in 1791. The first time that judicial review was established was 1803 in Marbury versus Madison. The second time it was used was not for 51 years later in the notorious Dred Scott case in 1854. So the Ninth Amendment is not largely about courts and was not intended to be about courts. What it means in an era of courts, as opposed to just something that informs political debate and ought to inform legislative action, is a very open question. And in fairness, it is not just Judge Bork, but people on both sides of the political spectrum, or all parts of the political spectrum, that are worried that the Ninth Amendment is so open-ended as to give carte blanche to virtually anybody to find whatever rights they may want in the Constitution, and as a result, it has become somewhat of a dead letter. Okay. What it was originally intended to mean remains some debate among historians. I'm no historian, so I'm going to let the historians debate that it has no important doctrinal effect now, nor has it ever had, is a fairly clear legal proposition. In this connection, what is meant by the term originalism with respect to an interpretation of the Constitution, and how is this term distinguished from the legal term strict constructionalism? Understanding this is a complex issue, I know it's very difficult to make concise, but can you advantage us with a general idea of the meaning? Sure. So when people talk about originalism, they talk about one of two things. Sometimes, as I was just saying, they talk about the original intentions, the original mental states of the people who wrote the documents. Sometimes, as with Justice Scalia, they're not talking about original intentions. They're talking about what the words of the Constitution meant at the time that they were written. Not what they mean now, but what they meant at the time that they were written. So people who argue for strict construction might be arguing for one of a number of things. They might be arguing for one or another of these two forms of originalism. They might be arguing against implied rights. So they might be arguing against, for example, the right of privacy because it's not explicitly written in the Constitution. Or they might just be arguing for courts in general and the Supreme Court in particular not doing too much, not making broad pronouncements. As a result, strict construction is a term you rarely see in the academic literature. It's more of a political slogan because it can mean so many different things. But probably most plausibly, there are serious arguments about how much and when the courts should interfere with majoritarian legislative decisions. That's a serious issue, and insofar as strict construction is the slogan that's on one side of that, it makes some sense, which is not necessarily to say it's right, but at least it's a coherent position.
Okay, very complex. In January, the Supreme Court issued a 5-4 decision, Citizens United, as we all know, on the question of spending limits in elections by corporations and by implication labor unions as well. Justice Kennedy stated that, quote, if the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. By definition, an independent expenditure is political speech presented to the electorate that is not coordinated with the candidate. Does this decision, Professor, equate, in your view, with the idea oft repeated in the press that money equals speech, or has the Supreme Court decision been somewhat misinterpreted?
Well, money has always equaled speech. The Supreme Court decided in a case called Buckley versus Vallejo in the 1970s that campaign expenditures were speech. But long before Buckley versus Vallejo, the great journalist A.J. Liebling said at the beginning of the 20th century, freedom of the press belongs to the man who owns one. That the ability to speak more and better if you have more resources is built into the First Amendment. Once we understand that, the rich and powerful can speak more often and more effectively by various different means than others, we can't completely separate broadly based, let's call it capitalist or free market ideas. The marketplace of ideas is, after all, a market. Justice Kennedy is in part echoing a significant part of the First Amendment tradition, but the real issue in Citizens United and other cases are elections different. What is the range of special rules about the electoral process to prevent elections from being bought? As opposed to, broadly speaking, is it useful to have more resources in the marketplace of ideas? Many people would say, yes, of course it's more useful to have more resources in the marketplace of ideas, but elections ought to be treated somewhat differently. The real issue in Citizens United is, are elections different?
Okay. As a result of this ruling, would further attempts at campaign finance reform potentially now violate the First Amendment right of free speech?
Some of them, yes. It's clear that Congress does not have the authority to overrule Supreme Court decisions. That's itself a little bit controversial. Presidents from both sides of the political aisle or spectrum, Abraham Lincoln, Franklin Roosevelt, Ronald Reagan, and others, have argued that they have their own authority to make constitutional determinations. Congress makes the same claim. But assuming for the moment that we live in a world in which Supreme Court interpretations are final, Congress cannot overrule the Citizens United decision. It has the power only to maybe make some minor adjustments in the cracks, but there's not much that it can do. Might be useful to point out that the United States has roughly the shortest constitution in the world. And by virtue of being short, It's vague, it's open-ended, it doesn't answer a lot of questions. The U.S. Constitution is about 12 pages long, Constitution of South Africa about 110, Brazil about 240. So we have a constitution with very little detail, and it's up to the courts to fill in the blanks.
In your view, Professor, does the 19th Amendment, which is the right of citizens of the United States to vote, shall not be denied or abridged on account of sex, does this give women enough protection under law, or should we revisit the idea of ratifying the ERA amendment, which has been bottled up in committee for a long time?
There's a third component to that. Nobody seriously claims that the 19th Amendment is a broad-based mandate of gender equality. There have been a large number of Supreme Court decisions starting in the early 1970s recognizing sex discrimination as a component of the equal protection of the laws. The degree of scrutiny, to use the technical term, is not quite the same as race, but laws that discriminate on the basis of gender, perhaps most prominently around here, the Virginia Military Institute decision of a few years ago, are, if not suspect in the constitutional sense of that term, at least suspicious. Many people have argued that even that is not enough, but most people, I think, would say that the routes to even more effective constitutional protection of gender discrimination are likely to come from the Supreme Court rather than constitutional amendment. The reason is simple. It's almost impossible to amend the Constitution. It requires 2/3 in Congress, 3/4 of the states. That means that the 13 smallest, that means that bare majorities, and in some states not even that, bare majorities in the 13 smallest states in the country can block a constitutional amendment. We amend our Constitution very rarely. We've done it only 16 times since the Bill of Rights. It's not going to happen with the Equal Rights Amendment. There are too many what-ifs out there. So as a purely pragmatic political observation, it's not going to happen. The changes are more likely to come as the court increasingly recognizes sex discrimination.
We have to take a break.
Sure.
We're talking with Professor Schauer. This is Politics Matters. We'll be back to you in a moment.